Welcome to another exciting installment of another chapter of the historical American court cases from America's historical past, provided by the Historical American Society of Historical American Past Cases from America. Today, we will be covering a court case from my own memories, Gibbons versus Ogden. Given the evidence, Fulton and Livingston has obtained the sole rights to operate ferries between New Jersey and New York. It is within New York's rights to operate ferries on its own waters. The Interstate Commerce Clause only applies to commerce, not navigation of waters, which does not fall under the category of commerce. Since these transportation interactions occur within New York State's waters, the New York's legislation holds supreme jurisdiction.
I'm taking you to court. The other court. You haven't seen the last of me.
All rise for the Honorable Chief Justice, John Marshall.
I'll be seated. Defendant Ogden, make your opening statement.
As stated by the state of New York, this individual has the exclusive right to operate steamboats within the state localities. The waters surrounding New York are under the sole jurisdiction of the state. The Interstate Commerce Clause does not extend to navigation and transportation on the high seas, but only to commercial transactions. Additionally, New York is not the only state guilty of making its own laws about interstate trade. Therefore, the state of New York has jurisdictions over its waters and matters of navigation, and can grant rights and permits to simply just operate on these waters, to whomever it chooses.
Thank you, Defendant Ogden. Plaintiff Gibbons, please make your opening statement now.
Permission to approach the bench, Your Honor.
Permission granted.
You see, according to the U.S. Constitution, Article 1, Section 8, it can be translated and directly applied to the commute between states. You are charging people for your ferry rides, aren't you? You see, the federal coasting license that I have received is completely valid and legal within the entire United States. And thus, it means that New York legislators does not have the sole right to grant Fulton and Livingston. Therefore, Ogden does not have the sole consent, permit, or authorization under the Constitution to do this.
I object.
I object to your objection.
You can't object to my objection. I object to your objection to my objection.
Boys, I think it's time for a recess. When you come back, I hope that both of you can conduct yourselves in a civilized and dignified manner. Out, now, go.
Settle things like real men.
With rock, paper, scissors. I'm gonna cut you. Rock, paper, scissors, shoot. Rock, paper, scissors, shoot. Rock, paper, scissors, shoot.
Come back, children. Recess is over. I'm ready to hear your closing argument. Defendant Ogden, do your thing.
Permission to approach the bench?
Permission granted.
As I have clearly stated before, the Interstate Commerce Clause only applies to trade, not navigation. so New York has the legitimacy and authority to grant privileges to whomever it chooses. New York State recognized my distinct, notable, and significant assets and fulfilled my small favor of indirectly issuing me this navigational license for purposes of navigation only, which gives me sole rights.
Gibbons, you may now make your closing argument.
You see, the Commerce Clause does apply to this case. You see, the federal coasting license supersedes the New York licensing, and it just all doesn't work that way.
Thank you, gentlemen.
I'm not
I've
even
heard
done
enough
yet.
now.
What?
And my final ruling will be made shortly. After much debate, I have come to my decision. The New York State requirement for licenses is inconsistent with the Act of the U.S. Congress, allowing the federal government to regulate trade. The word commerce in the Commerce Clause includes the navigation of waters of the interstates. Furthermore, among several states gives the power to regulate trade to the federal government and to regulate anything that isn't entirely internal. Therefore, this law is invalid because of the Supremacy Clause, Article 6, Clause 2, which defines the Constitution and the Acts of Congress as supreme law.
Gibbons versus Ogden was the most influential case I ever saw. It expanded the power of the federal government to regulate trade in more areas. It also expanded and encouraged trade opportunities between the states. In later years, it would allow for the development of train and roads. Gee whiz, that marshal sure was a great guy.
Wait. I know.
There you go.
Oh, sirens. Please go die somewhere else. We're filming.
The Commerce Clause. The United States. Oh crap.
Aw, you're laughing. Oh, pfft. Ah.
I should get an iPhone.
Merge them together.
Merge.
Okay.
Annie!
I can't do this.
Annie!
Oh my god.
Oh, Davina. It's not even funny. And I'm so tired.
Like a transvestite kind of thing.
Yeah.
Are you a female in this?
I mean, I'm supposed to be a male,
Yeah?
but I don't know. 'Cause I'm acting like
You're a girl, guy. You're a girl who's acting as a guy who acts like a girl. I don't know.
Who is in love with a guy?
Oh, my phone's. Oh, I need to put on my wig. Do you want to go out for?
Oh yes.
And Christy, make sure you don't laugh.
I'm not gonna laugh.
Are you sure?
Yes.